All right, welcome class. I expect your absolute focus today. You need to treat this explainer lecture not just as a casual discussion, but as the exact blueprint for securing maximum marks on a 16-mark examination question. We are looking at the privileges and immunities of members of Parliament and state legislatures. We're going to meticulously break down the exact literature you must present to your university evaluator to get those top grades. So let's dive right into this blueprint.
Now, the minute you receive your question paper, I want you to draw a neat box on the very first page of your answer script and write out this exact synopsis. 1. Introduction. 2. Meaning. 3. Types of privileges. 4. Importance. 5. Limitations or criticism. And 6. Case laws. This structural roadmap is going to immediately capture the evaluator's attention and establish that you have absolute command over the subject matter.
Let's start with Section 1, Introduction. Prepare to note down the precise constitutional basis of this topic.
Write this down exactly. The Constitution of India grants certain privileges and immunities to members of Parliament and state legislatures to ensure the independent and effective functioning of the legislature. Now, these are provided under Article 105 for Parliament and Article 194 for state legislatures. Listen to me carefully here. Firmly underline Articles 105 and 194 with a black pen in your answer scripts. The evaluator's eyes should instantly land on these two articles. They are literally the twin pillars of legislative privileges in India. An answer without them is simply an incomplete answer.
Moving on to the meaning. You need to write this definition word for word in your scripts. Parliamentary privileges are special rights, immunities, and exemptions enjoyed by members individually and collectively, without which they cannot perform their functions effectively. Now pause writing for a second. Effectively is the vital keyword the examiner is looking for. These privileges, they are not badges of some elite status, right? They are functional necessities. Without them, a legislator simply cannot question the executive fearlessly or debate laws effectively.
Let's move to Section 3, Types of Privileges. Under this, your first subheading is A, Individual Privileges. Make sure to use clear, underlined headings in your booklets.
You will structure your answer around these three exact points. First, freedom of speech in legislature. This means members have absolute freedom of speech in the House. No action can be taken in court for anything said inside the House. Second, freedom from arrest. Members are protected from arrest in civil cases during a session and for certain periods before and after. Crucially, it is not for criminal cases. Third, exemption from jury service. Members are exempted from attending courts as jurors or witnesses when the House is in session. Now, what is absolutely crucial for your exam is deliberately dissecting that second point. You must clarify to the examiner that the freedom from arrest is strictly limited to civil cases. This typically starts 40 days before a session and extends 40 days after. But listen, if a member commits a criminal act or is held under preventative detention, this privilege offers zero protection. None. Absolute conceptual clarity here is what guarantees those high marks.
Next, move to your next major heading, which is B, Collective Privileges of the House. These belong to the House as a whole. Keep your formatting crisp and organized, placing each point on a new line.
Let's go through them. Number 1, right to regulate internal proceedings. The House can frame its own rules. Number 2, right to punish for contempt. They can punish members or outsiders. Number 3, right to exclude strangers, meaning they can conduct secret sittings. And number 4, right to publish proceedings, where they can publish or restrict debates. Now, the specific point you must elaborate extensively on in your essays is the right to punish for contempt. Make no mistake, this is the supreme power of the legislature to protect its dignity. Whether it's an unruly member tearing up papers or an outside journalist writing a scandalous piece about the speaker, the House acts almost like a court to punish them. You've got to highlight this punitive power prominently.
Okay, Section 4, Importance of Privileges. A seasoned KSLU evaluator always looks for the why behind the law. Why exactly do we grant these exceptional immunities in a democratic republic?
Dictate this list exactly onto your paper. Ensure independence of legislature. Protect members from external interference. Promote free discussion and debate. Maintain dignity and authority of the House. Now, I strongly advise you to write these as distinct, unmerged bulleted points rather than a messy singular paragraph. Visually demonstrating to the examiner that you understand the multifaceted rationale behind the law is a very smart exam strategy.
Moving to Section 5, Limitations and Criticism. If you want to achieve top marks, I'm talking about the difference between a 12 out of 16 and a 15 out of 16, you must present a balanced, critical academic view. Simply praising the law is never sufficient.
Jot down these specific criticisms. First, they are not fully codified. which leads to uncertainty. Second, the possibility of misuse. Third, conflict with fundamental rights like freedom of the press. And fourth, it needs clarity and reform. I want you to pause deliberately on conflict with fundamental rights, because Parliament has deliberately chosen not to codify these privileges into a concrete statute book. They operate entirely on precedents. This lack of codification heavily shadows the citizen's fundamental right to free speech, leading directly to high-stakes constitutional clashes, and this perfectly foreshadows the most critical part of your answer.
Section 6, Landmark Case Laws. I demand your absolute attention right now. This is the heartbeat of a 16-mark constitutional law answer. This section will literally make or break your grade.
First case, I want you to draw a prominent box around this exact case title in your answer script. MSSM Sharma v. Sri Krishna Sena. Right below it, write relevance, freedom of speech and publication. This specific formatting guarantees the examiner immediately notices your depth of knowledge.
Write down the core issue here: conflict between freedom of press under Article 19(1)A and legislative privileges under Article 194. And the held: legislative privileges prevail over fundamental rights in certain cases. Now, let's do a deep breakdown of what actually happened, which you must explain in your paper. What are the brief facts? MSM Sharma was the editor of the Searchlight newspaper. He published portions of a debate from the Bihar Legislative Assembly that the Speaker had explicitly ordered to be expunged or deleted from the record. Naturally, the Assembly initiated a breach of privilege motion against him. Sharma approached the Supreme Court arguing his fundamental right to freedom of speech and press under Article 19 was violated. So why does this matter? What's the absolute relevance? Because the Supreme Court had to decide which part of the Constitution is superior. The court held that Article 194 is a special provision and Article 19 is a general provision. Applying the principle of harmonious construction, they dictated that the specific legislative privilege under Article 194 prevailed over the general fundamental right of the press.
You must write down this ratio decidendi with immense academic gravity. Legislative privileges prevail over fundamental rights in certain cases. Commit this specific phrasing to memory right now. Underline it in your exam. It establishes the initial superiority of parliamentary privileges over individual speech rights when they directly clash.
Let's move to your second boxed case. Write Keshav Singh's case, and critically, right beside it in brackets, write Special Reference Number 1 of 1964. Let me tell you, noting the exact presidential reference number is the exact kind of precise detail that drastically impresses university evaluators. Also write the relevance, scope of privileges and judicial review.
Note the issue at hand: the conflict between the legislature and judiciary over contempt powers. And the held: legislators' privileges are not absolute and are subject to judicial review. Let's break down this massive historical clash. Keshav Singh printed a pamphlet criticizing a member of the UP Legislative Assembly. The Assembly committed him to prison for contempt. Singh's advocate then moved the Allahabad High Court, and 2 judges granted him bail. Well, in an unprecedented move, the furious Legislative Assembly passed a resolution ordering the arrest of the 2 High Court judges and the advocate for breach of privilege. I mean, think about that. This created a severe constitutional crisis, prompting the President of India to make Special Reference Number 1 of 1964 to the Supreme Court. The relevance here is profound. The Supreme Court had to intervene to protect the judiciary itself.
The Supreme Court established the following ratio decidendi, which you will dictate exactly into your answer booklet. Legislature's privileges are not absolute and are subject to judicial review. Now, explicitly write in your exam how this verdict reconciles the tension established in the earlier MSM Sharma case. It's a brilliant evolution of the law. While legislatures have broad privileges, they do not act in a vacuum. Article 21, the protection of life and personal liberty, restricts these privileges. The House cannot just bypass fundamental judicial review. The court essentially said, you have privileges, yes, but you are not above the Constitution, and you are certainly not above the scrutiny of the constitutional courts.
We are finally at Section 7, Conclusion. Remind yourselves firmly that no KSLU answer script is ever considered complete with a definitive, well-articulated conclusion at the very end of the essay. A missing conclusion directly costs you marks.
Write this conclusion down verbatim and memorize it. Parliamentary privileges are essential for the smooth functioning of democracy, but they must be exercised carefully to avoid misuse and ensure harmony with constitutional values. This is the exact, perfectly balanced closing thought you must reproduce. It respects the necessity of the law while simultaneously advocating for constitutional checks and balances.
I will conclude this explainer lecture by leaving you with a provocative, exam-style theoretical question to ponder as you continue your studies. If parliamentary privileges remain uncodified, how can we truly ensure harmony between the authority of the House and the fundamental rights of ordinary citizens? Reflect on this deeply. Prepare well, structure your answers exactly as we have laid out today, and you will achieve the highest marks possible. Class dismissed.